Good afternoon, everyone. I hope you are all well. As the title suggests, today I'm going to talk about some recent review panel decisions relating to minor injury disputes. On reflection, however, it occurred to me as I was preparing this presentation that a more appropriate title might have been, "What is a minor injury is a major issue." By looking at these decisions, I hope to provide you with an insight into how the PIC is addressing some of the common injuries that form the basis of these minor injury disputes, and so make it easier for you to determine whether an injured person has sustained minor or non-minor injuries when you come to make your post-26 week and common law liability decisions. Looking at the review panel's reasoning in these cases should also help in the drafting of internal review decisions and submissions when minor injury disputes inevitably arise. There is a wide range of experience in the audience today, from new starters to seasoned professionals. So I apologise to those of you who are well acquainted with the content in the overview of the scheme that I'm about to provide. I promise I'll keep it brief, but hope that you will find it useful as a training tool. As we all know, the Motor Accident Injuries Act 2017 came into effect on 1 December 2017 and established a hybrid scheme for compulsory third-party insurance claims, providing entitlement to both statutory benefits and limited common law damages. Most significantly, under this scheme, injured persons are entitled to statutory benefits regardless of fault for a period of 26 weeks under Section 3.1 of the Act. However, if they are wholly or mostly at fault, or the only injuries caused by the accident were minor injuries, they will not be entitled to statutory benefits beyond this initial 26-week period. Although we know in some limited circumstances, injured persons with minor injuries may be limited to treatment and care expenses beyond this initial period. Also, and probably most significantly, injured persons whose only injuries are minor injuries are not entitled to common law damages. It is therefore not surprising that whether an injured person has sustained minor injuries or non-minor injuries is often not agreed upon and becomes a major dispute. Indeed, the significance of minor, non-minor determinations was addressed by the review panel in the decision of Talevska and AAMI Limited. In that case, the panel noted that for a claimant who sustains multiple injuries, only one of those injuries had to be found to be a non-minor injury to entitle the claimant to ongoing statutory benefits and common law damages. The panel went on to describe a non-minor injury finding as the key that unlocks the door to a claim for continuing statutory benefits and the gateway that allows the recovery of common law damages. The Act provides different definitions for physical minor injuries and psychological minor injuries. Firstly, I'll deal with the physical injuries. Essentially, Section 1.6 of the Act and Section 4.1 of the regulations work together to define a physical minor injury as a soft tissue injury, being an injury to tissue such as muscles, tendons, ligaments, etc. A complete or partial rupture of tendons, ligaments, menisci or cartilage is not a soft tissue injury, whilst an injury to a nerve manifesting in neurological signs apart from radiculopathy is classified as a soft tissue injury. No wonder the presence or absence of radiculopathy and the presence or absence of certain pathology on radiological scans have become a hotbed for dispute. Part 5 of the guidelines details the procedure for the assessment of minor, non-minor injuries. I'll not bore you with all of the provisions, however, it is relevant to remember that the guidelines provide that firstly, diagnostic imaging is not essential to the assessment. If imaging findings are used to support the assessment, they should correspond with symptoms and findings on examination. Secondly, the assessment is to be based on the evidence available and should include relevant findings from an accurate history from the injured person, review of all relevant records, and a thorough examination. And finally, any assessment involving the neck or spine must address whether radiculopathy is present or not. A finding of radiculopathy must be made in accordance with clause 5.8 of the guidelines, which I'll address further shortly. As promised, let's now look at some decisions. As you know, review panels are now made up of a member and 2 medical assessors. Their decisions, therefore, read more like those of a court or tribunal than a medical report. Whilst the decisions of one review panel are not strictly binding on another review panel, their decisions are persuasive, and as you'll come to see, they are often followed. The review panel's decision in David and Allianz is particularly interesting given their findings on radiculopathy and annular tears. Mr. David, the claimant, sustained multiple injuries, including an injury to his lumbar spine in an intersection collision on 15 November 2019. It is relevant to note that there was no record of any back complaints prior to the subject accident. The claimant's injuries were first assessed by medical assessor Bodell. He diagnosed a soft tissue injury of the lumbar spine and concluded that this was a minor injury for the purposes of the Act. The claimant successfully applied for a review. He argued that his lumbar spine injury was a non-minor injury as radiculopathy was present. He also relied upon an MRI scan undertaken following the accident which demonstrated a paracentral annular fissure at L5S1. He relied on a further MRI scan which demonstrated annular tears at L4-5 and L5-S1. The insurer submitted that the claimant's injury was limited to a soft tissue injury of the lumbar spine. They also submitted that the findings shown in the scan were incidental only and degenerative in nature, and the medical evidence was not supportive of a finding of radiculopathy. Let's first look at what the review panel had to say about radiculopathy. The review panel were not satisfied that radiculopathy was present on examination, as they did not find any of the clinical signs required by Clause 5.8 of the guidelines. You will recall that Clause 5.8 requires that 2 or more clinical signs must be present on examination for radiculopathy to be found. Those clinical signs include, firstly, loss of asymmetry of reflexes, positive sciatic nerve root tension signs, muscle atrophy and or decreased limb circumference, muscle weakness that is anatomically localized to an appropriate spinal nerve root distribution, and finally, reproducible sensory loss that is anatomically localized to an appropriate spinal nerve root distribution. Clause 5.9 provides that injuries to the neck or spine resulting in neurological symptoms that do not meet the above those criteria will be determined to be minor injuries. The review panel's discussion on the timing of radiculopathy is what makes this case particularly interesting. The review panel observed that it is not necessary that radiculopathy be present at the time of assessment, and that it was sufficient if radiculopathy was confirmed at any time following the subject accident. In coming to this conclusion, the review panel observed, among other things, that although the degree of permanent impairment must be determined as at the date of assessment under Clause 6.21 of the guidelines, there was no similar provision when it comes to the determination of a minor injury dispute. Symptoms of radiculopathy in themselves could fluctuate over time as the extent of the compression of the spinal nerve root may vary due to inflammation of the nerve root. And Clause 5.5 of the guidelines provides that the diagnosis must be based on a clinical assessment by a medical practitioner or other suitably qualified person independent from the insurer. In the panel's opinion, this suggested that the diagnosis could be made by a treating doctor. The panel concluded that a finding of radiculopathy was satisfied if radiculopathy is present at any time, although to constitute radiculopathy, at least 2 clinical signs must be established as specified by Clause 5.8. This is significant as it means that if a treating medical practitioner's records reliably confirm the presence of radiculopathy as defined under the guidelines at any time following the accident, a concession that the claimant's injuries are non-minor can be made. In this case, the review panel noted that although the claimant's treating neurosurgeon had referred to a decreased sensation over the left leg and foot and positive nerve retention signs, they did not accept that his findings satisfied at least two of the criteria as required by the guidelines. In addition, they noted that the MRI referred to a disc protrusion on the right side, but the claimant had left-sided symptoms. Annular tears. Okay, so this decision in David is also useful for the way in which the panel addressed the presence of annular tears on radiological scans. The panel accepted that the claimant did not have a history of lower back pain. There was no relevant pre-accident scan evidence, and that the claimant complained of low back pain shortly following the accident. Despite this, the panel did not accept that this established that the annular pathology was caused by the subject accident. They noted that annular tears were often found in asymptomatic people, and the claimant's lower back pain was likely due to a soft tissue injury of the lower back as opposed to the annular tears. The panel also referred to clause 6.121 of the guidelines, which essentially provides that while imaging and other studies may assist medical assessors in making a diagnosis, it is important to note that the presence of a morphological variation from what is called normal in an imaging study does not make the diagnosis. To be of diagnostic value, imaging findings must be concordant with clinical symptoms and signs and the history of injury. Now, strictly speaking, clause 6.121 relates to the assessment of permanent impairment. However, the review panel's reference to it in this case provides an indication on how they may address radiological findings. Now, the case of Maradi and QBE is another decision where the review panel were not satisfied that annular tears demonstrated on an MRI scan were caused by the subject accident. This case involved a 23-year-old claimant who was thrown off his motorbike after being rear-ended by the insured vehicle. At first instance, medical assessor Berry determined that the claimant sustained a minor injury for the purposes of the Act. The claimant successfully applied for a review, contending that he sustained a non-minor injury because an MRI scan taken following the accident had revealed annular tears at C5-6 and C6-7. The panel served research papers addressing findings of annular tears on MRIs. Despite being given the opportunity to provide submissions addressing these articles, neither side did so. The panel's examination revealed symmetrically reduced ranges of motion in the cervical and lumbar spine. Neurological examination of the upper and lower limbs did not reveal any abnormalities. The panel was not satisfied that either of the annular tears identified on the MRI scan were caused by the subject accident. They noted, firstly, that the symptoms reported by the claimant, including neck pain and stiffness, were consistent with a whiplash disorder of grade 1 or 2 severity. Secondly, there is essentially no relationship between pathology in the intervertebral disc, such as annular tears or disc bulges, and symptoms in people with whiplash. Thirdly, various papers had shown that annular tears were just as common in asymptomatic 20-year-olds as symptomatic 20-year-olds, and the presence of annular tears was not associated with neck pain. And finally, they found that whilst it was conceivable that an accident of this nature could cause an annular tear, they were not satisfied that the accident did cause the annular tears, having regards to the studies. They determined that the claimant sustained a minor injury and found it was more likely that other factors, such as damage to other musculoskeletal structures and psychological distress, were contributing to the claimant's ongoing pain. Moving on from the spine, let's now look at how review panels have dealt with pathology in other areas of the body. The decision in Venezuela and AAI addressed an injury to the left knee. Ms. Venezuela, the claimant, sustained injuries when she fell on the insured bus when it braked suddenly. it was accepted that she fell directly onto her left knee. At first instance, Assessor Wu determined that the claimant sustained only minor injuries. The claimant's application for review was accepted. Now, the issue for determination by the review panel, so far as a minor injury dispute was concerned, was confined to whether the claimant's left knee injury was a minor injury. The review panel were also tasked with making a determination with respect to whether a knee replacement undertaken on 19 July 2021 was reasonable and necessary. Now, the claimant had a significant history of left knee complaints and prior to the accident had been recommended a total knee replacement. However, she did not proceed with this surgery before the accident and immediately following the accident, the claimant complained of left knee pain, and an MRI performed post-accident showed a whole bunch of degenerative changes, including degenerative changes in the ACL and PCL, a macerated lateral meniscus with a large radial component, a moderate to severe chondropathy in the patellar femoral compartment, and also a likely old tear of the medial meniscus. The claimant alleged that following the accident, her symptoms were such that she decided to proceed with the total knee replacement, whereas before the accident, she was hoping to put it off for a further 5 years. The review panel determined that a physical examination was not required, particularly given that the claimant was recovering from surgery. The panel noted that the medical history and also the history that at the time of the accident, the claimant was independent in care, able to walk for several kilometres, was in full-time employment and was not taking pain relief medication for her left knee was significant. The panel noted that following the accident, the claimant continued to complain of a severe increase in pain in the left knee with swelling, locking and reduced range of movement and loss of function. Now, the panel considered that the onset of locking significant. They also considered the claimant's treating orthopaedic surgeon's findings that there had been an increase in malalignment between April and May 2020 as being significant. They noted that locking was often due to an internal derangement of the knee, allowing for the probability that in addition to an aggravation of the existing arthritis, there had also been some new internal mechanical damage. The panel accepted that a direct fall onto a degenerate knee could easily further tear a degenerate lateral meniscus and that the fall did cause further tearing. Having accepted that the accident caused further tearing of the lateral meniscus, the panel concluded that the accident caused a partial rupture of a degenerative lateral meniscus and such injury was not a minor injury for the purposes of the Act. Okay, moving on to the shoulder. The case of GIO and Teuk is helpful in that it addresses the relevance of contemporaneous records to questions of causation in minor injury disputes. The accident was a low-speed rear-end collision. At first instance, medical assessor Bodell diagnosed a right partial thickness tear of the supraspinatus tendon and certified that the claimant's right shoulder injury was a non-minor injury. He took a history that the claimant was immediately aware of right shoulder girdle and right arm pain following the accident, and it was on that history that he concluded that the tear was caused by the accident. The insurer successfully applied for a review. And now, the main issue in dispute was whether the claimant's right shoulder injury was caused by the accident, and if it was, whether it was a minor injury for the purposes of the Act. The insurer submitted that the first complaint of right shoulder pain was not made until 2 months post-accident, despite the claimant having been examined on several occasions during this period. They also submitted that had the claimant sustained an acute trauma to his right shoulder, there would have been evidence of reduced range of motion, pain, and reduced strength immediately following the accident. As a matter of procedural fairness, the claimant was afforded an opportunity to explain why there was no records of complaint of shoulder symptoms until 2 months after the accident. The claimant maintained to the panel that he had complained of shoulder symptoms during this period, but could not explain why there was no record of any complaints in the records. Now, the review panel acknowledged recent decisions such as Norrington and QBE, which had found that review panels and medical assessors had fallen into jurisdictional error by treating the lack of contemporaneous medical evidence as determinative of the issue of causation. However, they observed the notes provided by the ambulance service and hospital were detailed and suggested, in their words, precision in questioning and recording. Further, they observed not only was there an absence of right shoulder problems, but the hospital records referred to there being no upper limb abnormality. The panel further noted that the claimant had not referred to a right shoulder injury in his claim form and considered that this was also a factor relevant to whether a body part was injured. They further noted that the claimant could not offer any explanation as to why this injury was omitted from his claim form. They considered that the history given on re-examination, that his right shoulder complaints commenced immediately following the accident, was just grossly inconsistent with the medical records and the claimant's own claim form. Ultimately, the review panel did not accept that the right shoulder was injured in the subject accident, or the accident caused or contributed to the supraspinatus tear. Now, in my opinion, this case and the previous case of Venezuela demonstrate the importance of the clinical history being consistent with radiological findings in establishing causation. So where there is an inconsistency, it should really be emphasised in your submissions when a dispute arises. Okay, now let's turn our minds to psychological injuries. Section 1.6 of the Act also includes the definition of minor psychological and psychiatric injuries. It provides that a minor psychological or psychiatric injury is one that is not a recognised psychiatric illness. However, Section 4 of the regulations also operates to include acute stress disorders and adjustment disorders in the definition of minor psychological injuries. Clause 510 to 512 of the guidelines referred to the procedure for assessment of psychiatric injuries for minor injury disputes. Essentially, these provisions provide that the assessment must determine whether a psychiatric illness is present using the Statistical Manual of Mental Disorders, also known as DSM-5. If the symptoms do not meet the diagnostic criteria for a recognised psychiatric illness, except of course for acute stress disorder or an adjustment disorder, the injury will be found to be a minor injury. Now, the case of Lynch and AAMI is interesting for a number of reasons, including the diagnosis made by the panel, their adoption of the decision of David discussed earlier, and their observations on which party bears the onus of proving that an injury is a non-minor injury. The claimant, Mrs. Lynch, a traffic controller, sustained injuries in a motor vehicle accident on 5 June 2019. A dispute arose as to whether her psychological injuries were minor or non-minor, and her claim was referred for a minor injury dispute. In the first instance, medical assessor Jones concluded that the claimant sustained a chronic adjustment disorder with depressed mood and mixed anxiety, which we know is a minor injury for the purposes of the Act. Relevantly, he noted that the claimant had anxiety related to driving, but had been able to return to that activity and had also returned to reasonable function in a number of areas, despite ongoing complaints of mental health problems. The claimant applied for an application for review of Assessor Jones' certificate. This was accepted, and the review panel determined that re-examination was required. At assessment, the claimant reported being psychologically affected by the accident in 2 ways. Firstly, she described anxiety related to being involved in a further accident and car travel in general. And secondly, she described depression in the context of ongoing neck pain and physical restrictions. Now, regarding her anxiety relating to car travel, the claimant reported only driving if she had to, and if she did drive or travel as a passenger, would startle easily. She reported some dreams of being involved in a car accident. She reported moving closer to the city so that she would not have to drive as much, and avoided driving in the rain completely. She described feeling depressed due to the changes in her life and having to leave her job. She described losing interest and enjoyment in many activities and had recurrent thoughts of suicide. After starting a new job and receiving treatment, her depressive symptoms improved. The panel noted that the claimant did not satisfy all the criteria for a diagnosis of post-traumatic stress disorder, as she did not consider that she was seriously injured at the time of the accident. However, they accepted she had persistent symptoms of anxiety and fear of being involved in another accident, which they found satisfied the DSM-5 criteria for a specific phobia of driving, which is not a minor injury. The panel observed that a diagnosis of an adjustment disorder could not be made if the stress-related disturbance met the criteria for another mental disorder. Now, I don't know about you, but I cannot recall a claimant having ever been diagnosed with a specific phobia of driving under the old scheme. Now, the panel also, in addition to that diagnosis, accepted that the claimant had experienced an episode of major depressive disorder, but her depressive symptoms improved and she was currently in remission. Now, you'll recall the case of David discussed earlier, where the panel noted that a finding of radiculopathy was satisfied if it was present at any time following the subject accident. The panel adopted the same reasoning in this case as far as it was relevant to the diagnosis of a psychiatric condition. They noted that DSM-5 provides for a diagnosis of major depressive disorder, which can be described as either in partial or full remission, and such diagnosis, which describes a past condition, was a diagnosable psychiatric condition. Further, adopting David, the panel noted that the diagnosis did not have to be made by a medical assessor and could be made by a treating medical practitioner. The panel went on to make the following useful observation at paragraph 72, that the psychiatric diagnosis may change over time is not only consistent with the provisions of DSM-5, but otherwise consistent with physical injuries. A simple fracture is a non-minor injury within the meaning of the Act, but will normally heal prior to any assessment. It would be an absurd interpretation to conclude that as the fracture has healed, there has been a change in status from the injury being classified as non-minor when the injury occurred to one being classified as minor because the injury had healed. Finally, the decision of Lynch is helpful for what the panel observed about which party bears the onus of proof in these disputes. Now, in the submissions made by the claimant in support of the application for review, the claimant contended that the onus of proof was on the insurer to establish that the injury was minor because the diagnosis of a minor injury is a disentitling provision. The panel observed that such submission focused only on the impact of the diagnosis on the claimant's entitlement to statutory benefits and did not address the fact that the diagnosis was also a precondition to recovering damages. They noted that Section 4.4 relevantly provides that no damages may be awarded to an injured person if the person's only injuries resulting in the motor accident were minor injuries. Having regard to the principles of statutory construction, which I will not bore you with today, the panel observed at 51 that when read alone, Section 4.4 places the onus on the injured person, as it provides that no damages may be awarded if the person's only injuries were minor injuries. The panel found that the word if in Section 4.4 operated as the conjunction whereby there is a prohibition against obtaining damages if the only injuries were minor injuries. The panel further observed that Schedule 2 of the Act, which includes a dispute about whether the injury caused by the accident is a minor injury for the purposes of the Act as a medical assessment matter, suggested that there is only one assessment of minor injury for all purposes of the Act. In their opinion, it was not consistent with the objects of the scheme for separate determinations of minor, non-minor injuries to be made in respect to statutory benefits and then a separate determination being made for common law damages claims. The panel therefore found that the claimant bears the onus of establishing that an injury is a non-minor injury for the purposes of the Act. Now, the final decision that we will look at today is the decision of Wong and NRMA, which is interesting for how the panel addressed the impact of a subsequent stressor on the claimant's psychiatric diagnosis. The subject accident, a rear-end collision, occurred on 10 September 2019. At first instance, medical assessor Jones concluded that the claimant did not have an active psychiatric disorder for the purposes of the Act. The claimant successfully applied for a review of Assessor Jones' assessment. The review panel re-examined the claimant when they accepted that she did not have pre-existing psychiatric complaints. According to the claimant, she became anxious in the subject accident, but had no major worrying thoughts about being severely injured in the accident. Following the accident, the claimant's symptoms of depression and anxiety worsened. Initially, her symptoms were related to the shock of the accident and subsequently were related to her mother's deteriorated physical health and dependency on her. The claimant's mother's cancer diagnosis also had an additional impact upon her psychological health. However, the panel found that the claimant's mother's diagnosis, although unrelated to the subject accident, had, in their words, not severed the chain of causation, and the accident remained a significant causal factor in her current psychological injury. They diagnosed a persistent depressive disorder, noting that the claimant's depressive symptoms had persisted since the accident, which had occurred more than 2 years ago. Her symptoms were noted to include depressed mood, poor appetite, insomnia, fatigue, poor concentration, and feelings of hopelessness. The panel therefore certified that the claimant had sustained a non-minor injury for the purposes of the Act. The panel noted that the claimant's symptoms were not severe enough to justify a diagnosis of major depressive disorder. They also noted that the subject accident was not a threat of serious injury or death, and as such, the claimant did not fulfill the criteria for a diagnosis of PTSD. The panel also adopted the observation on the timing of non-minor injury addressed in Lynch, but in any event found that the claimant was presently suffering from a non-minor injury. So, after all of that, how can we use these decisions in our day-to-day management of claims? With respect to deciding whether a claimant has sustained a minor or non-minor injury for the purposes of your liability decisions, it's important to consider, firstly, in the case of injuries involving the neck or back, whether the treating medical evidence includes a reliable diagnosis of radiculopathy under clause 5.8 of the guidelines. Now, whether or not this is done by a neurosurgeon doesn't necessarily mean that you can reliably find that there is radiculopathy, as we found in the case with David, where the panel found that neurosurgeon's clinical findings did not meet the diagnosis. Now, secondly, where there are radiological findings, it's important to remember that the presence of annular tears and other similar pathology in the spine are not likely to be found of themselves to be non-minor injuries. Also, where pathology has been identified in any part of the body, it's important to really look at whether that pathology is consistent with the available clinical records. And finally, for psychological injuries, whether the treating medical evidence includes a reliable diagnosis of a psychiatric condition in accordance with DSM-5 at any time following the accident must be considered. Now, moving on from liability decisions, we can also use these decisions with respect to drafting of submissions for minor injury disputes. It seems that the review panels are now in the habit of following decisions of previous panels. So if a previous decision is relevant to your current dispute, it would be helpful to address it. For the pathology relied upon to be of significance, it must be consistent with the clinical history and examination findings. It is therefore worthwhile making submissions on this issue, particularly if there are any inconsistencies. Thirdly, although not determinative, a lack of contemporaneous complaint of injury may support a submission that the injury is not accident related, particularly if those contemporaneous records are detailed. And finally, it is worth remembering that the claimant bears the onus of proof in establishing that their injuries are non-minor. Now, we have put together a minor injury guide for you, which we'll email to you all. It has more information. It will hopefully help you when you come to a matter that stumps you a little bit about radiculopathy, annular tears, psychological injuries. You can click on the links and it will take you to some case notes about those decisions that just provide you with a little bit more information and our contact details. Thank you for your time. I will open up to any questions. If there aren't any questions, everyone can have an early mark, or feel free to email me because my details will be on the guide that will be provided. Thank you all so much for your time today.